side, I suppose. Let me get off away from the camera. So, Kaylee, what's supposed to happen at exactly 9?
They're going to hear some motions, and then...
Over at... Oh, that's happening right here.
Yeah,
okay.
And then the jury selection process will start at that gym. Mm-hmm. And then around 1, they're going to start to bring the first few groups out of that here.
Okay.
So that's going to be deciding whether or not we can provide that jury selection.
Yeah, parts of it.
So at 9 a.m., let me get off the camera. At 9 a.m., the judge will begin to hear motions.
Mm-hmm.
And also at 9, that's when jury selection.
Yeah, so let's see. The first 200 are reporting, potential jurors reporting to Selden Park gym at 9 a.m., around 9 a.m. And then 20 out of those 200 will be called to the courthouse and come here around 1 p.m.
20 of 200 will report to courthouse at 1, you said?
Yep. And then throughout the whole day today, there will be 600 have been summoned to that gym. Mm-hmm. And then they're going to be coming over in pools of 20. And then another 400 will come to the gym later in the week.
I thought it wasn't until the 25th, right? Is that this week? That's next week.
Sorry, you're right. Yeah.
Okay. First 200 reporting at 9 a.m., 20 of the people. And we'll report to courthouse at 1 p.m.
Yeah. Those 400 are technically on standby, but...
All right, Mindy. Waiting. Oh.
Is that Renata's car? Is that your car?
That's mine. Well, Richard. FYI, waiting on your cue to start. Okay, let me go to our website in the meantime. So the feed will be on the motions. That's what we're showing at 9.
I believe so.
What am I looking for? Oh, yeah, our website. Hey, Mindy.
I was on the phone with Harold. You're up.
I'm up right now. Okay, thank you.
Yep, so you can start whenever. Thank you.
Mm-hmm. Hello? Hello?
Good morning, Keitha. How are you feeling today?
I'm okay. I should be on right now. Do you need something emergency, like right now?
Oh no, sorry.
Okay,
I'll be back
bye.
with you.
And welcome in. So you are watching First Coast News' live online coverage of the trial and the death of Ahmaud Arbery. Ahmaud Arbery, you know, at just 25 years old, was shot and killed in the Cecilia Shores neighborhood of Brunswick within Glynn County. This happened back in February of 2020. Now we're in November of 2021. And still the family waits for justice. This entire town right now within Glynn County, they're waiting to see what will happen next. A lot of anxious people, they're afraid of what will happen, particularly with outsiders. That's something I've been hearing a lot. They're afraid that people are going to come in from outside to be agitators in this case. But overall, we're just hoping for a peaceful end to all of this. Now, it took a lot just to get to this point. We want to bring in now First Coast News reporter, on your side reporter Kaylee Tracy, who has been covering this trial since the very beginning. She is joining us now with a look back, how we finally got here to this point. Now, you have spoken to just about everyone. We're talking about Ahmaud's mother and father, countless family members, because it's a very large family. Take us back a little bit. How did we get to this point?
So the timeline, of course, February of 2020, that is when Ahmaud was killed in the neighborhood Cecilia Shores, about 15 minutes from where we're standing right now at the courthouse. He lived just across the street. His family says he was out for a jog. The defendants in this case maintained that they thought that he was a suspect in a burglaries in the neighborhood. We come to find out nothing had been taken from the home. He was seen looking into that home under construction, now actually pretty much finished over there in that neighborhood over a year later. Yeah. And then flash forward to May. It took until May until that infamous video now that came out, and that was actually leaked by an attorney, a local small town attorney. And we know now that that is kind of what was the catalyst for this case and launched it to the national stage. It's been through several hands. The former district attorney here in Glynn County, who has now been indicted on charges related to this case of how she handled it initially. It went through another district attorney, another one after that. The GBI, ultimately the Georgia Bureau of Investigations, took it over, and just within a few days they made those arrests. Of the McMichaels, 2 weeks later, they arrested William Roddie Bryan. He, for those who aren't familiar, he's the one that was behind the camera.
The neighbor, correct?
The neighbor in that neighborhood who was in his truck on the other side of things. Kind of prosecution says Ahmaud in on both sides there. So from May, now we're here over a year from that timeline later, and it's finally going to trial.
You say finally, and something that I've been hearing a lot is folks saying, how is it possible to actually choose an impartial jury in such a small town? I mentioned again Ahmaud Arbery. His father, Marcus Arbery, has about 9 siblings, so you can imagine the connections here. But it's about to happen. Now, they cast such a wide net when it comes to the jury pool. We're talking about 1,000 people, potential jurors, but it has been broken down because this morning they're only expecting about 200 or so to report to Selden Park, not too far from here, a couple of miles away, and they will then be later brought here to the courthouse. You will actually be inside the courthouse. You'll be in here for the next several weeks, as a matter of fact. This will go on for quite some time. We're expecting jury selection to last about 2 weeks.
And just to give perspective, this is a county of about 85,000 people. So you ask, I was up here last week, and you have been talking to people too. Anyone out here in this town knows about this case. It's hard not to, and that is why we're told 1,000 people is a large number, but they want to make sure they get an impartial jury. And I've actually had questions even from my own mom about why they haven't moved this case out of Glynn County if it's such a small town and everyone knows about it. Well, usually they look at the jurors, see if they can get that net of impartial jury of 12 jurors and then some alternates, and then the judge will determine, okay, do I need to move this or not? So we're not at that point yet, but potentially.
We're waiting to see what will happen for sure. You mentioned people knowing what happened here. We know in the questionnaire that was sent out to the jurors, the potential jurors, they were asked, do you know about this case? What do you know? So you could imagine, I couldn't picture not one person saying, I don't know about it, I'm clueless about it. So this will be very interesting. We're all watching closely to see exactly what will happen with this jury pool. Again, as we mentioned, 200 today. We will wait to see from just that 200, we're expecting about 20 people to show up at this courthouse because as you see, it's not a very large area because when you hear 1,000 people, you're a little overwhelmed how they're actually going to converge here, but they are breaking it up.
And then we know by the end of today, 600 potential jurors will report to that gym. Again, as you said, not too far away. 400 more next week, and then they'll be brought in pools of 20 throughout that course to see who they can get.
And if you're wondering about the breakup, obviously they're concerned about COVID. We all are. There are a lot of protocols in place right now to try to keep people as safe as possible. Now, Selden Park comes into mind with that. The reason they chose that location is because of the ability to space folks out, hopefully safely. Again, there's a waiting period to see what will happen. We know Glynn was hit pretty hard by the pandemic, like so many other areas are. But
and a lot of people also, Keith, in this town are talking about logistics. They last week had that town meeting. They're planning with their law enforcement out here, and they said, look, this is something we want to keep in a small town. We don't want to have to bring in National Guard or anything like that, and they want to recognize people's right to protest if they want to be out here. They had some people over the weekend who had peaceful demonstrations, and that's something that a lot of people out here in town wanted us to mention is everything has been peaceful in this town. There haven't been any riots or anything like that. All the demonstrations have been peaceful, and they want to keep it that way. They have said some of these streets in this area will be closed off for a lot of the trial. Obviously, we're standing right in front of the courthouse, and this is kind of like media row, if you will. But this street behind us will be closed, and some other ones in the area. They do have some barricades, which you can't see off camera, ready in case, and they say they will be ready, but they don't think it will escalate to that level. And just like the locals here, they've said it would be out-of-towners potentially. And they're warning them, if you want to do something like that, don't come here.
That's right, you said it. And the key word there is peaceful with the demonstrations. Just people I've spoken with, they're saying just that. They're worried about outsiders, not people within this area. Outside agitators possibly coming here and causing trouble. That's something they're warning you, urging you not to do. I can tell you there's already a lot of security around here. I was out here earlier for Good Morning Jacksonville at about 6 or so, and we saw officers walking by with dogs. I asked him, what are you doing? The dog was sniffing for bombs, sniffing our live truck. So that tells you something, right? They're not playing around here, not messing around at all, trying to keep safety in play. Now, I want to go back a little bit because a good part of this as we head into the coverage is trying to give people an update, catch them up at everything. And as I mentioned, Kaylee has been on top of this since the very beginning, so she knows a lot of intimate details. Let's talk specifically about the DA that we know was in question, because we know that Gregory McMichael, one of the McMichaels who are on trial right now, he worked with the DA at some point and had a relationship with her.
He was a former officer. He had been retired at the time in February of 2020, but he was also an investigator prior to that with Jackie Johnson's office.
Right.
So we know from court records and evidence that he was actually, his first phone call after the incident was to Jackie Johnson.
Wow.
She did not answer, and there's no evidence that she called back after he left a voicemail. But if you've watched some of the body cam video from right after, you can see him getting recognized by some of the officers on the scene, and him kind of saying, you know, this is who I am, X, Y, Z. So that is one of actually the charges that she's indicted on, related to not immediately having the officers, in layman's terms, arrest the McMichaels in the first place or sooner.
But you know, that's a concern, not just in Brunswick, but a lot of these small towns, is that because everyone, they're somehow connected, they know each other, are they treating each other fairly in a case like this? Right. So that's why we saw outside counsel brought in, and let's delve into that as well.
So the Waycross district attorney who took it over, Jackie Johnson, actually recommended that he take it over. But one of the charges we now know also is that she actually consulted with him for help before she handed it over to him. She asked, how should I handle things? So that was, and she did not tell, you know, the Attorney General that she had done that before she recommended him. So then it went to a third district attorney as well. And then from the scope of how big the case was getting, the Georgia Bureau of Investigation ultimately took over the case.
We have a lot of moving parts here, but we are aligned, so things are going to be a little rough. Right now we have Ann Schindler. We're not going to bring her in just yet, but she is down at Selden Park, where, as we mentioned, a lot of the jurors are being they were summoned. They're actually there right now ahead of the actual selection. We're going to get to Ann in just a second as she's walking around, but since we still have Kaylee, I don't know for how long, because she has to get inside. It's 45 right now. Do you have time to stick around, or you're heading? Okay, you let me know when. We don't want to keep you too long. But you were, again, delving into the background that you know so intimately. So let's talk a little bit about the McMichaels, what we know about Travis, who is the son here, the actual person who pulled the trigger, that shotgun, who we're told fired at Ahmaud 3 times with the shotgun. We know Ahmaud ultimately was shot and killed, and Gregory McMichael, his father. So what do we know about these two?
So we know they were living in a house right there in Satilla Shores, not too far down from that house under construction in the neighborhood there. I also want to talk about Roddie. Bryan, we know he was a former mechanic, obviously not anymore. All 3 of them have been sitting in jail since their arrest. There have been plenty of times their attorneys have tried to get them out of jail, and the judge just said, no, you know, you're going to stick here. We know that Travis McMichael, the son, he has a son himself. That was part of his plea to, you know, I'm a father. And, you know, there's other evidence, too, that just recently motions were filed to not have he has a Confederate type sticker on his license plate, to not have that used in court, or pictures of it. That was struck down by the judge, and so they could use that. So there's a lot of factors in this case, and just a lot of motions that we've heard over the past year, really, and we're going to hear just a few more this morning before the jury selection starts.
I'm glad you mentioned that, because we're getting little bits and pieces of what we can expect, what's to come. At 9 o'clock at Selden Park, we know they'll begin the jury selection process there. But here at the Glynn County Courthouse, right behind us where we are right now, what's set to happen here at 9?
So we'll hear just a few motions, including some from the media, about getting more access to inside the courtroom. We know because of COVID precautions, it's limited to just around close to 40 people actually in the overflow room during the trial.
Right.
There's some other logistics that the judge will hear this morning as well.
Yeah, you say close to 40 people. I can tell you right now, the first day of jury selection on this Monday, there's way more than just 40 cars out here, because you can imagine the amount of people that are going to be here as in the days coming, right? So there's no way that 40 will be able to fit inside of there. So we're waiting to see what will happen of that. Exactly. That's helpful to mention, because as you know, we're online right now. This is a part of our coverage of First Coast News. We're going to be covering this for you gavel to gavel, both on air and online. And don't forget to download that First Coast News app, because that way you'll be able to get the stream and instant updates. As soon as we know, you will know as well. Again, Kaylee, I still want to look ahead with you as much as possible. Give us a breakdown of the jury selection, what you know thus far.
Sure. So like we were saying, by the end of today, 600 people will have gone over to that gym. The first few hundred this morning before around 9 a.m. and then by 1 p.m. we're expecting again about 20 of them to be brought over here who have kind of made the cut, for lack of a better term, to be brought in potentially as jurors. And then 600 again by the end of the day over there, and throughout the week they'll be brought in kind of pools of 20 people over here as they kind of decipher who's gonna make the cut again. And then next week we'll have the next 400 go over to that gym. As you said earlier, we're expecting the jury selection to last potentially up to 2 weeks. They want to make sure they get everything right for an impartial jury, and then the trial, of course, will start. Be out here probably about a month, if not more. We're expecting from at least day one today.
Yeah. Now, as I mentioned, Kaylee is very in tune with this trial. I want to talk about Wanda Cooper. We're talking about Ahmaud Arbery's mother. You had a chance to speak with her. I mean, what was that like? What is she saying? I could only imagine what she's going through right now to know that we've finally gotten to this point.
So she's speaking with us tomorrow, but the family overall has spoke with Ahmaud's father, who has kind of said, up until this point, it's been just waiting in anticipation for this, and just now that this day is here is almost, they're just hoping for justice and hoping for the best. His aunt actually spoke at that town hall last week, speaking of protests and that sort of thing, and said, look, again, we've been very peaceful, our whole family has, and we've been out here at these demonstrations as well, and that's how we want to keep things. So the whole family on board, peaceful protests for justice for Ahmaud.
You spoke with some people in the area just this week. You were just here. I mean, what were you hearing? What's the vibe?
So a lot of people, again, are saying that they think people in this town, they'll remain peaceful. They're worried potentially about outsiders coming in and what they call seizing on this moment, which they don't want, obviously. I've also heard from a woman who works just downtown here, and she said her husband doesn't want her to go to work for the whole trial. She's going to be working from home just in case, because you never know. So they said that they'll be ready for anything, but they're hopeful, at least the people of Glynn County, they know how to act and they'll stay peaceful.
I know you're going to have to run pretty soon, Kaylee, but briefly, if you can, tell folks any tidbits, what we should be looking out for today in particular.
So today, mainly those motions that we talked about, we'll have updates on that, and then we'll have the latest on narrowing down the jury. I think as we get further along in the week, we'll have a better number and a better outlook on how long this jury selection will take.
Yeah, you have about 10 minutes before trial starts. You are a wealth of knowledge. We'll be bugging you, pulling you in throughout the duration of this. But your Twitter account, briefly, because we'll all be following you for updates, because you're really good with that as well.
Thank you. It's at Kaylee Tracy, and Kaylee is Kailey. Tracy, Tracy.
Thank you, Kaylee. We appreciate it. And folks, again, you are watching First Coast News' live online coverage of the trial and the death of Ahmaud Arbery. Now, this is something that will be going on in the weeks to come, and we will continue to stream it for you here live online. And don't forget as well that First Coast News app for instant updates. Right now, I have Ann Schindler on the phone. She as well knows very well the intimate details of this case. Now, Ann, we won't be able to see you, but I'm going to talk with you and get some tidbits about things. So, folks, it's a little rough. It's online, but bear with us. Ann right now is actually at Selden Park, which we mentioned is just a few miles from here where we are right now in front of the Glynn County Courthouse. Now, Selden Park is where we are expecting to see those jurors show up today. They should already be starting to show up in that area, because at 9 o'clock is when things should get underway, that jury selection process. We're expecting about 200 or so people to show up there at Selden Park. Now, this is out of a really large pool of about 1,000 people who were sent jury summons. Obviously, they won't all be there today because there are a lot of concerns when it comes to COVID. Obviously, there are a lot of protocols in place, so they're trying to keep people as safe as possible. I just got a mic in from Richard. Thank you very much. And we're going to try to have Ann here and try to get some tidbits from her. Good morning, Ann. How are you?
I'm good, Keitha. Good morning to you. I actually passed by you all a short while ago while you were at the courthouse. It is pretty quiet around Brunswick. It seems very, idyllic here, lovely at Selden Park. This is where the jurors are gathering. I just a moment ago spoke briefly to Sheriff Neil Jump. He's here on the premises along with a number of law enforcement who are checking in potential jurors as they arrive. I only see maybe, 100, 125 cars or so in the lot here right now. Mm-hmm. But the jurors are gathering inside, and security is present. Definitely a lot of law enforcement here, but like I said, it seems very peaceful here. The sheriff said things seem to be going very smoothly this morning so far, and they're, I guess, going to be doing their initial qualifying of the jurors here, asking them, this is sort of a hardship stop where they'll be asking jurors whether there is something very fundamental that would prevent them from serving. This isn't a question about bias or their exposure to the case. It really is whether they are physically able to sit through a trial, whether they have someone that they're caring for that they can't leave for more than a few hours, that kind of thing. And people who clear this stop will then come over to where you guys are to go through their initial jury questionnaires and then to voir dire, which will get deeper into the usual questions they ask jurors, about whether they've been victims of crime or have a family member in law enforcement or that kind of thing. So this is really the start of a process that's going to go through 3 steps and take some time. I don't believe they're expecting to see anywhere near 1,000 people, even though that's the summons they've put out. Mm-hmm. I think the clerk has said they're expecting a fraction of that, which I think is typical for jury duty. But that's a process that's, starting today and will go until tomorrow. I think another 400 jurors will come tomorrow to begin the process to make sure that they've got a thorough jury pool to begin with.
Now, if you're just now joining us online, we want to clarify some things. You might be wondering exactly what's going on. So we are live in front of the Glynn County Courthouse ahead of the trial in the death of Ahmaud Arbery. Currently, I have Ann Schindler on the phone, someone who is very intimate with this story. She has a lot of intimate details. She's been following this very closely. She's with First Coast News on your side, and she is right now at the Selden Park location, Selden Park Gymnasium. That is where we are seeing hundreds of potential jurors showing up this morning. The very, very beginning of the weeding out process. I have her right now live on the phone with us. We just had a chance to chit chat with Kaylee Tracy, on your side reporter, who is on her way into the courthouse right now as they begin to start reading the motions. But right now, let's get back to Ann Schindler. And you mentioned security. I've got to tell you, we were out here early this morning, about 5 or 6 or so, and we saw officers coming by with canines. And I asked I said, what are you doing? And they were actually bomb sniffing canines, just going through the live trucks, making sure that everything is safe here. So there is a large security presence already, definitely necessary, we believe. But again, right now, things have been very peaceful overall. And people in this community that you talk to, they're praying, hoping that things remain that way. Again, I want to get back to Ann Schindler. You mentioned that pool of 1,000. They're not expecting that many people to actually show up, but that net, casting such a large net, was very much necessary to try to get a jury that is actually impartial, which will be difficult in this trial. Let's talk about that.
Yeah, Keith, I'm having a little trouble hearing you, but I think I got the gist of it. And, what they're going to be looking for in jurors here, because it's a small town and because it's such a big case, they're not necessarily going to be looking for people who haven't heard of the case, which is very often what they try to look for in a juror when it's a high-profile case. Here, they're really going to be asking people whether they can set aside what they know about the case, focus just on what they're told in the courtroom, and they're going to be looking for people without a firm mindset about the case. And that really is going to be, I think, the difficult part. This is a case that has been very, I don't want to say polarizing, but it is a case that people have formed some very firm opinions on, I think, just because of the nature of the case. the allegations that the prosecution is making about the motives of the defendants, and then the defense's claims about, what they thought Ahmaud Arbery was doing. And it has created, I think, very firm opinions in a lot of people. And of course, it has gotten a tremendous amount of attention, both on mainstream media and social media. So they're going to be looking for jurors who are able to say that they can set aside, any information that they've heard, that they haven't formed a firm opinion about the case, and that they're open to hearing the evidence that's presented. But again, it's a small town, and it is a town in which a lot of people know one another. They have not made the the judge has not made the move to move this trial. Typically what they'll do is see if they can seat a jury and go through this entire process. If they are unable to, I think at that point, moving it to a different venue, a different jurisdiction would be something, of course, that they would consider. But judges these days, typically, rather than just move a trial, like to go through the process to see if they can seat a fair and impartial jury. And they're hopeful they can, casting a net of 1,000 potential jurors with those 1,000 jury summons.
Yeah. You were just hearing from Ann Schindler right now. She is on the phone with us live from Selden Park, where we know potential jurors are gathering this morning. And thank you very much for your time. We appreciate it. We only have about a minute or so before we get into our live feed inside of the courtroom. Thanks, Ann. I'm going to hang up with you. We'll likely pull you back in later on throughout the day. Folks, we will be here live, on air, online throughout the duration of this trial. This is the trial in the shooting death of Ahmaud Arbery. Again, Ahmaud Arbery was just 25 years old when he was shot and killed in the Satilla Shores neighborhood here in Brunswick within Glynn County. Right now, we are right outside of the Glynn County Courthouse, where in just a matter of moments, trial will start to get underway. We're talking about jury selection. That will happen today. We heard from Kaylee Tracy, On Your Side reporter, just a couple of moments ago about what is set to happen inside of that courthouse. Right now, we're going to hear, the judge will hear motions, so that will get things going. You heard from Ann just now, who was at Selden Park where the potential jurors are. She is clarifying what's going on there. Right now, they're trying to weed through things, trying to figure out exactly who cannot serve on this jury for whatever reason may be. This is going to take some time. This is going to be a lengthy process. They're estimating about 2 weeks or so for this jury selection process. We will simply have to wait and see what will happen next. The big thing here that you're hearing from people around this area within Brunswick, within Glynn County, is that they are hopeful that this will remain peaceful. That is a very big part of this, because we know there are protests not just here within Glynn County, but across the nation that happened when Ahmaud Arbery lost his life. So they're hoping again that this will remain peaceful throughout the duration of this trial. Again, we will be here. First Coast News will be here for you both on air and online covering this. And don't forget to download the First Coast News app. We're going to give you instant updates as soon as they come in. And right now we are going to go ahead and let you listen in live to what is happening inside of the Glynn County Courthouse.
Do what? Yeah, oh God, good. Well, good comment.
He says he don't want.
He don't want to.
He's already in a
Trial, trial.
Okay. So I don't even have anything hanging up here. Okay. Hey, so what y'all think about bringing him up by 10 till or letting him know?
He's going to talk to the attorney. See what screen or something. He's going to talk to the authority.
Okay.
I'm sure there's multiple chances. Yeah, but you can split screen and have it put over those people. That's going to be an extension of that. How big do we want to test them? Because whatever we could do at the same time. I think that is. What's that?
If you're getting one running, right?
Yeah.
And it's up there, and you just shrink it, it's not a window, shrink it and do another one.
Yeah, well, at least the other day,
So in terms of having
yeah.
So at one point, probably a couple of weeks, they're going to be playing deposition. During that deposition, that witness is looking over the evidence. We want to feature those at the same time we play it. So I'm wondering how we can do that. Put a couple of things in the same story. Separate. Play it all. We just use like a computer. That's the video of the deposition now. Yeah, just gonna get a tissue. Oh. It's gonna be a video.
there ain't no more shingles over there.
Right now,
Yeah, that's what I'm talking about. We need one out there, we are definitely one short.
Just like
still.
You can see me?
Yeah.
Hey, Laura, can you see me okay? You what? Oh, right here? But you can't even see me on that screen? Hmm.
Just waiting on Kevin.
Pardon me?
I was saying, we're just waiting on Kevin.
I got you.
He needs to address this first. He does it. He does it every time.
I don't think one time. The judge was only on the bench and he wouldn't even show the ball. Should have struck something. But I think he's done that before.
He
bet, yeah.
Well, the judge is already here.
And ready to go.
Yeah.
Half these motions probably here. And he ain't here. Let the judge know. Attorneys. Attorneys.
Does that come to the jury box?
Yeah.
Yeah, y'all just cut to the jury box.
Jason,
Yeah.
as our associate, she should be able to.
Not so far. So we thought it was clear. Shauna is an attorney in our office and Lee are our support staff. So we need them to be able to use their devices so they can communicate with us. That includes her laptop. We didn't say the little laptop back there though.
No, we didn't say a laptop.
We didn't say the little laptop. So, do we need to go ask the judge again, or are you comfortable with the purpose of what we're doing, is just to allow them to be able to communicate with us, not take pictures, not tweet, not all that stuff.
Okay. I'll ask you.
Okay.
Okay. I'll let you know.
Yes, Mr. Chairman. Come to order.
All rise. Glynn County Superior Court is now session on Timothy Walmsley presiding. Please sit.
That's an ominous start. Any idea where that's coming from? All right, good morning. We're on State of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. Any idea where that feedback's coming from?
We're fixing to get IT in here.
Okay, let's get the, we'll work through the feedback in just a second. Let's see if we can get started, though, without too much of an issue. All right. The defendants are present, represented by counsel. State is here, represented by the district attorney's office. The plan this morning is there are a couple of motions that are pending. There's some motions to intervene. We plan on starting jury selection today at 1 o'clock, so I wanted to make sure that we addressed any issues with regard to jury selection. And if there is any particular motion in limine that we have to address now from a timing standpoint, I want to give the parties the opportunity to go ahead and do that. But really the plan this morning is to get organized so that we can go ahead and start addressing the panels this afternoon. With that being the case, anything from the state as a preliminary matter?
Nothing from the state, Your Honor.
Anything from Travis McMichael?
No, Your Honor.
Anything from Gregory McMichael?
You're just wanting to hear about other motions pending that don't have to do with jury selection or anything that's...
No, what I'd like to do is address anything having to do with jury selection. And then depending timing-wise, if there is something from a planning standpoint with a motion in limine that's sitting out there, because again, we've got a little bit of time before we actually get to openings in this case and get into the evidence. If there's anything that we need to address from a timing standpoint, I'm happy to try to address that this morning.
Nothing besides voir dire issues, Your Honor, for us, on behalf of Greg McMichael.
From Mr. Bryan.
Nothing besides voir dire issues, Your Honor. But we do have some of those.
And I know, Mr. Goff, I've received proposed general questions from the state as well as the McMichael's defendants. I have not seen any from you. Do you plan on submitting any?
We have no general questions, Your Honor. And furthermore, we're withdrawing the previous request for a juror questionnaire, which I think the court's pretty much already denied it, but we would withdraw that. We have no general questions.
Okay, thank you. All right. All right. What I'd like to address first then, I've got at least two motions to intervene. Make sure I got both. All right, the first is filed by, let's see, Mr. Clyde, Mr. Fugate. It's a motion to intervene to ensure access to jury selection. Are either of those individuals here on behalf of the Associated Press, AJC, CNN, Court TV, Media Convergence Group, doing business as Newsy, Cox Media Group, as well as some of their affiliates and others?
Good morning, Your Honor. My name is Leslie Gaither on behalf of the media interveners as well as Rachel Fugate.
All right. If y'all just come on forward then.
Thank you, Your Honor.
Good morning. Is there any objection to the interveners on the issue of access to jury selection?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right. We'll go ahead and permit the interveners on the issue of access to jury selection, more specifically on the motion by media interveners to ensure access to jury selection filed October 14th of 2021. Go ahead.
Thank you, Your Honor. I will keep it brief. Basically, we wanted to address three things in our motion. One, I think, is already taken care of. It was just a little bit of kind of confusion in the air about the media folks having their electronics in the overflow room. I think everybody who has a Rule 22 has been able to bring in their electronics, so I think that's a non-issue. The issue for us for access for jury selection is kind of because of the interplay of Rule 22 and access for jury selection. So basically, because of the way Rule 22 operates, we cannot record, and the court's decorum order, we can't record the jurors' faces and we can't record the potential jurors' voices. So if no one from the media is allowed in the courtroom or in the overflow room, it's basically closed. We basically have a closure issue because there's no way for them to see what the potential jurors, there's no way for them to see what's going on in the courtroom and what the potential jurors are saying. So what we've asked the court for basically is for a small number of seats in the courtroom for the media that they can decide amongst themselves who has, so someone can see what's going on in the courtroom, and then the use of the overflow room, like a live stream in the overflow room that wouldn't be recorded. So it would serve kind of as an extension of the courtroom. So a way for them to see what's going on in the courtroom without being physically present in the courtroom, given the size and the COVID restrictions and whatnot.
And then you said there was a third issue.
The third issue was the electronics issue, which I believe is a non-issue.
So really the two other ones that are access by the pool in the courtroom and then access by the media to jury selection in the jury assembly room.
Exactly, Your Honor. A live stream in the jury assembly room, because we can't record, because when the pool takes it outside, they wouldn't be able to show the jurors' faces, they wouldn't be able to record what the potential jurors are saying, so there's no real kind of access outside because of the restrictions of Rule 22.
Okay. Anything from the parties on the matter?
No, Your Honor.
Judge, our only concern is that the jurors remain anonymous. We trust that the media will be able to keep their names out of the picture, keep their voices out of the picture, keep their picture out of the picture. As long as that's in place, then we have no objection.
Is it all right if I speak from here? I think
That's fine. As long as the podium is being used, I think we can pick you up. If not, I'm sure somebody will let me know.
All right. I usually don't have that problem, but you let me know if it is. I have been in communication with Mr. Clyde and Ms. Gaither, and she kindly sent to me the authority upon which her clients rely in asking that the court leave individual voir dire open to the media folks that are in the overflow. And we've agreed that that's the case, that they'll be identified by number only, that there'll be no contact with jurors or prospective jurors by the media. There'll be no attempt to interview jurors or prospective jurors until the conclusion of the case and in the matter that the court allows, in the event that the court allows such a thing. There'll be no publication by any means of photographs, video, or visual reproductions, which would be sketches of any juror or prospective juror. Jurors' names are not to be used in the media discussion of this case during trial. But they do concede that there are instances in which a juror may be unable to provide a complete and candid response during individual voir dire if they know that the media has access, that anyone else has access to this very sensitive and private information that they want to reveal, that they need to reveal. So, based on the case law that Ms. Gaither sent to us, to trigger a consideration of an in-camera voir dire, the prospective juror must make an affirmative request. So, as a result, Your Honor, we are going to be asking the court, whether you do it to the panel, which may be more expedient, to let the jury pool know that if a particular juror has a significant and sensitive privacy concern in respect to a question that's been posed, the juror may request to speak to the judge and counsel separately regarding that particular area of inquiry only. And that's the concession that we've reached with each other, because the concern that Ms. Gaither's clients had was that we had originally asked for a wholesale closure of the courtroom during individual sequestered voir dire.
All right, so one of the challenges in this case is going to be the questionnaire that was sent out, and I find it hard to believe that there aren't going to be, well, if not every individual that's going to come in is going to end up having to respond to questions about the questionnaire. What I imagined would probably happen with that was that would be done in the courtroom as opposed to before the rest of the panel, because I do not want information from individual jurors about what those individual jurors may have learned about the case being discussed amongst the entire group.
Yes.
So how is that going to be addressed?
Well, as we understood your original order, you were going to conduct the statutory questions, provide those to the panel, which you'll be bringing in 20 at a time, as we understand. And after you've gone through the statutory questions, each side will ask their general questions, but the only thing that that juror can do is to raise their hand if they're answering in the affirmative. We're then jotting down those numbers, and the only conversation that's going to take place will be an individual voir dire. So there will be no tainting of the panel of 20 if the individual voir dire is the only place that we cover their knowledge of what they believe they understand and know about the case.
Okay.
Thank you, Your Honor.
All right. Mr. Goff.
Your Honor, we have nothing to add.
All right, so and I need to then make sure I understand exactly what's going on in the jury assembly room. I don't have an issue with permitting pool access into jury selection. The problem is the amount of room I have. We are very limited on room. So, and that applies also to the courtroom itself. What I will look at in order to address the issues that are brought up is whether or not we can get a pool reporter into the jury assembly room. And then I need to work through exactly what to do about the courtroom itself. And that should permit, and I believe the jury assembly room is being live streamed out. I thought there was a camera in there.
My understanding is now the camera that's in there is the same pool camera, so it's not recording it wouldn't record what under Rule 22 exactly what the potential jurors are saying, so it wouldn't be a true live stream. Because it's the pool recording camera that wouldn't be showing the faces of the jurors or the voices of the jurors.
So what you're looking for is, in addition to what is being pushed out as images, some access to a pool reporter just to report on what's happening in the room.
Well, yeah, exactly. A live stream of what's happening in the room, yeah. As well as...
What do you mean by a live? I'm not going to permit an extra recording. What I think I'm prepared to do is allow a pool reporter in to report to the pool on what's happening there. But if there's already images being pushed out, and that's what I'll check on, then that's covered.
But our concern is the images aren't being pushed out because under Rule 22 you can't, it wouldn't be duplicative of what's in the courtroom because you wouldn't be getting the potential jurors' voices, the answers to the questions. You wouldn't be getting any images on who raises their hand, who doesn't raise their hand, etc. because of the recording prohibitions under Rule 22.
I'll look at what the live stream is out in there.
Okay.
I'll just have to check and see
Okay.
how we're set up. One of the challenges being a Chatham County judge coming into Glynn County is that I'm not exactly sure exactly how they've got it set up right now, but I will make sure that we do that before we get started.
Understood. Thank you, Your Honor.
And Your Honor, we have one other logistical issue that coincides with that, and that is how you would want to handle an in-camera sequestered voir dire inquiry. Whether that the authorities provide for it happening in the courtroom if the courtroom's cleared. But that could get kind of tough. The other is that it can be done in camera and in your chambers, in your current chambers.
Yeah, well, let's address that if it comes up. We'll see what the status of the courtroom is and how exactly logistically we can do that. Because we can either do it in here and just shut everything down and clear it. I agree. That may not be as easy as you've indicated. But if we need to do it in the back, there's more than enough room, I think, in the back to do it.
Yes.
Okay.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right, thank you. All right, there's also another motion to intervene. Filed by, let's see, Mr. Bauer on behalf of WXIA TV, WMAZ TV, WJXX, First Coast News Jacksonville. Is anybody here on the intervener's behalf? Let's be clear about it. I've got a motion and a request for an emergency oral hearing filed on October 14th at 7:15 p.m. on behalf of those interveners. Is there anybody here on behalf of those potential interveners? Can we check in the hallway? understand there is, although there are representatives of the media organizations that are referenced in the motion, I do not have counsel here on that request for an emergency hearing and the motion to intervene. The court is denying the motion. All right, those are the motions to intervene that are currently before the court. Let's go ahead and move on to issues with jury selection. So to get everybody where I am on this, I received from the state as well as the McMichael defendants proposed general questions to the panel. I've reviewed those. I'm happy to hear from the parties on the proposed questions if the parties wish to address the court at this time. So let's start with the state's proposed questions. Mr. Okowski.
Yes, Your Honor. The state did submit a list of general voir dire questions to you. At this point in time, the state has some concerns about the defendant's questions. Did you want me to address those first?
I was going to take it one at a time because I know I've received something at least from the Greg McMichael's counsel on the states. I just want to make sure that and I guess let me be a little bit more clear. What I received, it was a little while ago, so I want to make sure we're all on the same page. There is a set of general questions. It looks like it's 7 pages long that the state intended to use. I assume the state is still going to be asking to use those questions in general voir dire.
Yes, Judge. Those are our questions that we submitted a couple months ago. We are still intending to go forward with those particular questions.
All right. And I received a objection from Mr. Hogue. I'm not sure whether counsel had coordinated on that or not. So,
We're together on that.
so Mr. Hogue, the state's general questions.
Yes, Your Honor. So the first objection we have is to the very first statement. It's not really a question. The state says, I am not going to ask you a series of questions, or I am going to ask you a series of questions, but before I do, I want to let you know that this is not a death penalty case. Our objection to that statement is that it's unnecessary to raise the subject of the death penalty in voir dire or at any other point in this case. Other than this question, the subject of the death penalty should never arise unless a juror during voir dire brings it up and asks us if this is a death penalty case. I think that's highly unlikely, but if they were to do that, then we just answer them and tell the individual juror, no, it's not. You don't need to worry about that. Raising the subject of the death penalty in general voir dire to all these potential jurors, I think would engender more questions than it purports to answer. A juror could wonder, for example, whether this could have been a death penalty case, whether it may have been a death penalty case at one time and the state's taken their notice off, or wonder why the state isn't seeking the death penalty. Those are the kinds of questions a juror could think up once they hear the words death penalty and begin to wonder, why did you tell us that? So it's unnecessary in examining jurors regarding any matter about which they might have an inclination or a bias or a leaning to bring up the death penalty. So we object to that first statement on that basis. I have other comments. You want me to stop?
Let's get through all of them.
Okay.
Instead of addressing.
One concern is just a matter of clarification, and I think based on what I'm hearing this morning, it may be cleared up. But one of the questions the state asks is, do you know me? And in parentheses it says Judge Walmsley. So I took it from that at least when they wrote these, the state was thinking that the court was going to propound all of these general questions. But I'm hearing this morning responses to my co-counsel, by your honor, sounds like you're allowing counsel to propound the general questions. Okay. The next one I have is at the bottom of page 3. I have an objection to the question, is there anyone here who believes that the assistant district attorneys are from Atlanta or are associated with the Fulton County District Attorney's Office, formerly under Paul Howard, now under District Attorney Fani Willis? Our objection is that that question is unnecessary and irrelevant. Whenever the assistant district attorney or the DA and all the other assistants that are with the state are introduced, I imagine that the jury will hear that they are from Cobb County. I doubt any juror here will be confused to think that Cobb County is somehow affiliated with or within the Fulton County government in some way. And so injecting Fulton County, former DA Paul Howard's name, current DA Fani Willis's name into voir dire is irrelevant to examining jurors about any perceived impairment they may have or any inclination, leaning, or bias they may have. So I think it's probably more confusing to raise that question than it solves. The other objection on page, well, it's on page 4, is a question, are you any of you related by blood or marriage, third cousin or closer, to the defendants Greg McMichael, Travis McMichael, or William Roddie Bryan in this case? The kinship question was included above. I may have added it, I can't remember. It looked like the first set of questions on page 1 were the statutory questions from 1512-164.
An expanded group of statutory questions.
They were expanded, but whenever I saw a statutory question that should have been included, I went ahead and included it, but I put it in brackets so the court would know and the state would know that in the digital version I sent this morning, anything in brackets is what I've added to it. So that kinship question already appears on page 1 in the statutory questions. So the only objection there is it's repetitious. You would have already asked it. Same with the bottom of page 4, any relation by blood or marriage to Ahmaud Arbery is a kinship question that should have been covered already above in the statutory questions. But I presume the court will be asking, and if not, I'll be moving the court to ask the statutory questions rather than the state.
Just so we're clear, normally I just have the clerk read the statutory, or ask the statutory questions on behalf of the court.
Yeah, anybody but the state will be satisfied with that. And I'm going through the notes here. That was all I had on the state's general voir dire questions, Your Honor.
Mr. Bryan.
Your Honor, the only question I have a problem with is there's a question in there not asking the jurors whether they know or know of counsel in this case, but asking about their character and reputation. At least that was in an earlier draft that I saw. I have no objection inquiring of the jurors as to whether they know or know of counsel and how they know them and whether that would affect their ability to be fair and impartial. I think that's fair game. But the question is phrased is highly improper, and I will move for a mistrial if that question is asked as phrased.
All right. From the state on those objections.
Yes, Your Honor. Your Honor, through the state's experience having picked numerous juries, especially after the court has read the indictment, this indictment has murder, felony murder, felony murder, felony murder, felony murder in it. And jurors often assume, because they've been called to a murder trial, that this would in fact then result in potentially being a death penalty case. And normally, when the judge asks the statutory question, can I be fair and impartial, you get a couple of hands that go up. And when you ask them, well, why can't you be fair and impartial? They say, well, I can't sit on a death penalty case. Well, if we haven't already informed them that this is not a death penalty case, then we get them answering, yes, they can't be fair and impartial because of that. Once that is removed from their mind, that the only thing they're going to do, which by the way the court is going to instruct them in their jury charge, that they are only concerned with guilty and not guilty. They are not to consider sentencing at all. And that is a charge this court will be giving them in the jury charges. And it's just a courtesy to let the jurors know that that is the only obligation they have here, is to come back with a verdict that speaks the truth, guilty or not guilty. And to take that particular burden of, well, it's a murder case, so is it not? That uncertainty. And I understand what Mr. Hogue is asking for is that, well, let them bring it up. But the problem is jurors are nervous. They are being questioned individually by all of us here. And it's very, very difficult for them, I think, to speak up sometimes. And to have something like that weigh on their mind, it would just be easier to take it off the table. The idea that saying the words death penalty is somehow going to trigger a whole bunch of stuff in their heads, well, reading a murder indictment is also going to trigger a number of things in their heads as well. So we are just asking that the court inform them that that is what it's going to be. It's not a death penalty case. It's going to be guilty or not guilty. And that's the only thing they're to consider for themselves in this process. Thank you on that one. With regard to the assistant district attorneys are from Atlanta and not associated with the Fulton County District Attorney's Office. Your Honor, obviously the state has interviewed the witnesses and spoken with them. And what the state has heard repeatedly from our witnesses, whether they be law enforcement or lay witnesses, is you all are from Atlanta. And I understand why. Glynn County and the district attorney's office here is part of a 5-county district judicial circuit. So what you have here, and what everyone's familiar with here, is a 5-county judicial circuit. We are from Cobb County. It is its own judicial circuit, but that's not commonly known amongst other people when it's Atlanta, Cobb, Gwinnett, DeKalb, Clayton. Well, all that must be one big judicial circuit in the city of Atlanta. We just want everyone to understand that we are an actual separate entity that is to the northwest of downtown Atlanta and not necessarily associated with the Fulton County District Attorney's Office. We would, of course, understand if that is something the court eliminates from our questions. And then lastly, I did have, is there anyone here especially familiar with Mr. Kevin Goff through reputation or association? And that was simply because he is the one local attorney that the jurors may actually be familiar with. We are from Cobb County. The other defense attorneys are not from Glynn County or Brunswick. He's the one who may be known. And I didn't mean anything by reputation or association. I just meant, have you heard of him? Do you know him? Have you ever worked with him? That was simply what was meant by that question. I can rephrase it if it would make everyone more comfortable. Thank you.
No, we have no objection to her rephrasing it. That's the phrase. That's our
Yeah, I assume it's really the question. Well, let me get to them one at a time. All right. So with regard to the state's voir dire, that first question about the death penalty, if it comes up through a question, that's fine. The court's not going to be, it's not going to be coming from counsel or the court. So that is not going to be asked as the first question in the case. Again, the statutory questions we'll go ahead and address through the court. The question, as far as to me, the whole thing about Cobb County versus Fulton County and Atlanta, that's not going to be asked. To me, that's more confusing than anything else. I mean, we're in Glynn County, and that may be something in the metropolitan area that is an issue or needs to be clarified. But here, we're making it clear, I think, through all of these questions that the Cobb County District Attorney's been appointed to try this case, and will do so. So we're not going to be asking about Atlanta and Paul Howard and those issues. The familiarity with Mr. Goff, I would suggest, is there anyone here especially familiar with Mr. Goff or has been represented by Mr. Goff? That strikes me as a fair question. There are a couple of questions buried in here by the state that are covered by the statutory questions, for example, related by blood or marriage. I would suggest that the state go ahead and take a look through that just to make sure that we're not duplicating questions. I say this to all the parties. We're going to be pushing for time. I don't rush anything in a case, but I also don't want to just burn time for the sake of burning time. We have a lot of jurors that would like to get through the court in order to determine when and if we can have a panel in this case. And the longer we spend on each individual question and each individual phase, the more concerned I get about how this is going to go. So I only say that because there is some duplication in here. There is a question here the court noted that was not brought up in the objection. There is a, specifically is raise your hand if you or a close relative or very close friend has been involved in a citizen's arrest. That's a legal term. The court's not going to permit that question. There's also a number of questions the state is proposing about the use of a handgun. It goes from use of a handgun to does anyone have in your household a rifle or shotgun? Have you had to use a rifle or shotgun for a non-sporting purpose? Please raise your hand if you ever had a handgun, rifle, or shotgun pointed at you. My notes here was to narrow that down to one question, is whether or not anyone in the household owns a handgun, rifle, or shotgun. If the state wishes to follow up beyond there, welcome to do so. But whole thing about, so we're going to limit those questions really to one, if that can be narrowed down. Also, as Mr. Hogue pointed out, these questions were drafted, it looks like, from the perspective of the court. And so there are a couple of questions, or a couple of statements at the end. I'm going to instruct you. The court's not going to be instructing the panel in jury selection on these issues of law. For example, well, unless they come up, and the court needs to clarify anything that's happening. All the instructions at the end, the court is not going to get into. And I think that addresses the court's issues on voir dire from the state. Does the state understand the court's instructions?
Yes, Judge. So what the state will do is it will go ahead and consolidate. Do you or does anyone in your household own a handgun, rifle, or shotgun? And then the state would like to ask, has anyone ever carried a gun as part of their job or had firearms training? But we will consolidate those other 4 questions into one question for expediency. And yes, Judge, I did write this with the intention that you would be giving the general questions to the jury. I will pull out any of those questions at the very end that are as if you are speaking to the jury.
Okay. All right, then. I have proposed general questions from Travis and Gregory McMichael. I received, it looks like 2.5 or so pages from the defendants. That is what I have been working off of. Would that be Mr. Sheffield, Mr. Rubin, Mr. and Mrs. Hogue? I assume these are the questions that are being proposed by those defendants.
That's correct.
Yes.
All
Yes,
right.
Your Honor.
Anything the court needs to address in there before I ask for any objections?
Not from us, no. Those are the 30 questions we propose to ask.
Anything from the state?
Yes, Your Honor, we have several objections. First off, regarding number 10, I'm assuming this is asking the jurors, does anyone here agree with the statement that no one should be allowed to shoot an unarmed person under any circumstance? This is basically calling for prejudgment on the particular facts of this case. And then number 11, I'm assuming once again that they would ask it in the form of, is there anyone here who agrees with this statement? No one should ever put him or herself in a situation where he or she might have to use a firearm for self-defense. Once again, state objects to that. It seems as if it's prejudging, and it's basically asking the jurors to put themselves in the position of the defendants, and we would object to that. Regarding participation in any of the demonstrations or marches related to the social justice movement before or after the death of Ahmaud Arbery. That question has absolutely nothing to do with what the defendants did on February 23rd, 2020, and participating in a constitutionally allowable peaceful assembly about social justice has absolutely nothing to do with these defendants. So we would object to number 12 as well. Number 13 is, do you support in any way the Black Lives Matter movement, where support includes positive thinking or positive thoughts to financial support to signs or bumper stickers or statements on social media? Once again, Black Lives Matter has absolutely nothing to do with this particular case. I'm going to suggest an alternative, which is, what bumper stickers or magnets do you have on your car? Do you have yard signs? What do they say? That question, I think, would go ahead and elicit a better response as to where that person may stand with what they put in their yard or communicate on their car to other people. And number 14, do you believe that anyone who opposes the Black Lives Matter movement is a racist? There's absolutely no evidence in this case that anyone involved in this case opposes the Black Lives Matter movement. That also goes with talking about that movement and demonstrations having a positive effect on the community. That's number 15. We object to that. And 16, do you agree with the statement? This case has been important in revealing the racism in our community. Well, what has that got to do with the guilt or innocence of these defendants, about the aftermath of this case and everything that took place? Asking about whether the media has done a good job covering this case fairly. Once again, we'd object to that. That was number 17. Number 20. We object to, do you agree with this statement? The Confederate flag is a racist symbol. Same question for the old Georgia state flag.
We have that as 19.
I have it as 20.
I have it as
So the
20.
state flag.
Mm-hmm.
We got one off somehow.
All right. Once again, 23 is sort of in the same bucket with the asking the jurors, do you believe this makes this person a racist? Do you believe this makes this person a racist? So there's a propounding of a number of questions where they want the juror to say, I guess, that, oh yeah, if somebody does this, I automatically think they're a racist. Those sorts of questions, I think, are inappropriate, especially for voir dire. Number 23, white people who use the N-word are racist. Getting them to agree or disagree with that statement. I believe we've got number 24, which is very similar to the citizen's arrest sort of question, which you've already excluded from the state. Do you believe that a citizen should never attempt to detain a person suspected of a crime under any circumstances? So once again, we've got prejudging once facts not in evidence and calling upon a legal concept there. Number 25 is regarding mental health. To ask this question in this context, you've already ruled that this is inadmissible evidence. So asking this sort of question in voir dire is inappropriate because it's not going to come in. That also holds for number 26. If I may have one moment. We're very concerned about number 29. This is sort of the, are you concerned about your safety, your reputation, or your livelihood if you were to be a juror on this case? That's the please feel free to raise your hand and give us some excuse because we've just told you that we'll consider this. People serve on juries every single day in this country. They serve on murder cases every single day in this country, including cases that are televised or that are controversial. So at this point, to ask that question is just basically asking every juror to raise their hand to be asked to be let off this jury. And those are our objections, Your Honor.
Mr. Hogan.
Yeah, there's a keyboard and a mouse right here on this lectern. I presume I can move that. I don't know who put it here or what it's for.
It's not mine. You can't.
Thank you. I'll just put it down here. In fact, I'll stick that down here if you want to. Thank you. I believe the objections began at question 10. I'll try to stick with the numbering. I think we got off somewhere. I might have deleted a question after I sent those to the state and to the court. But with respect to question 10, the way we've phrased it is no one should be allowed to shoot an unarmed person under any circumstances. Of course, it's a hand-raising question, and we would follow up in individual sequestered voir dire to talk about it. But under 1512-133, of course, the statute that guides us here on individual examination, without reading the whole thing, the important part is that we're looking for any inclination, leaning, or bias respecting the subject matter of the action. The question's designed to discover any jurors who may have an anti-gun opinion or anti-gun violence inclination, leaning, or bias, even in self-defense situations. While I think it's highly unlikely that jurors will say, I don't agree with the use of firearms, even if defending oneself to the death and using one, but violent gun use in self-defense is a subject in this case. And so under 1512-133, we're looking for any inclination, leaning, or bias respecting the subject matter of this case. So that's the defense to question 10. Would you like me to go forward and address each one?
If you could, please.
And I think the next batch was, did you object to number 11? 11? Okay. The response is the exact same as I just gave for number 10. It's 1512-133, inclination, leaning, or bias. Subject matter of the case obviously concerns the use of a firearm in what the defense will say is a self-defense. That's what's at issue. It is the subject of the case. And so this question, like 10, helps us look for jurors who might have an inclination, leaning, or bias, so that we either may find out if they're legally impaired and move to excuse the juror for cause, or use a peremptory strike, which is, of course, the purpose of voir dire, is to determine which jurors may be impaired and which jurors we would like to strike with our peremptories. The next questions were all of those in the group, I believe, from 12 down to 21, maybe. I tried to take notes quickly which questions the state objected to, but all of those have the same defense, 12 through 21, so I'll just state that. And again, it's our dependence on OCGA section 1512-133 concerning the subject matter of the action and our efforts to find jurors who may have an inclination, leaning, or bias that would help us determine whether that's a juror that should or should not sit on our case. So each of those questions achieves that by asking. We do know that race is an issue in this case, and naturally we would be allowed to discuss race. And these are just ways to get at that and find out from potential jurors whether they might have inclinations, leanings, or biases that render them unsuited for this case. Now, I haven't discussed with co-counsel, but let me look here. One of them I may withdraw. Let me continue with 12 through 21, and if I've got the numbers off, I'd like to clear that up. But I have 22 as the N-word question. Is that what everybody here?
I have it as 23.
23. All right, so I must have deleted a question along the way, but 23, I propose that we withdraw that question. Co-counsel.
23.
It's 22 on your list.
Let's make sure.
It's the N-word question. This one right here. So we will withdraw question 23, the N-word question. But if I can back up just a minute, I see I have other notes to defend questions 12 through 21.
You don't need to do 20 or 21 on your list. They
Okay.
didn't object to those.
Okay.
And they didn't object to your 18.
All right, so it's, just so we can get the record clear, which
12
questions?
to 17 on yours.
12 through 17?
And then 19 and 22 on yours.
Okay.
And then 23 through 26 on yours, and 29 on yours.
All right, so the defense to 12 through 17 then. Yes, the follow-up in individual voir dire with those questions could develop for us and explore a juror's thoughts and opinions on those matters in order to determine whether a substantial impairment may exist such that a cause strike is supported, or if no substantial impairment, then enough information, and now I'm quoting from a case I'll cite. The quote is this: to enable counsel to identify those prospective jurors counsel desires to remove from the panel by use of peremptory strikes. That's Henderson v. State, 251 Georgia, 398 at 399, a 1983 case. And then also citing a U.S. Supreme Court case, Turner v. Murray, M-U-R-R-A-Y, 476 U.S. 28 at page 36, quoting, a defendant accused of an interracial crime is entitled to have prospective jurors informed of the race of the victim and questioned on the issue of racial bias. Those questions are designed to get at possible bias that's based or related in some way to race. All right, and Laura, help me out. What's the next one? 19. '19 is the Confederate flag question. And we actually, this is how I got off. You have a Confederate flag question and an old Georgia state flag as a separate question, Your Honor, in the state, or no?
My number 20 is a combined. Do you agree with the statement, the Confederate flag is a racist symbol? Same question for the old Georgia state flag.
Okay, I have that as 19, but that's the question, and it's two questions in one, and I was wondering maybe that's how our numbering got off. Yes, those questions, again, under 1512-133, help us explore any inclinations, leanings, or biases any jurors may have regarding the subject matter of the case. Many people, of course, consider those to be racist symbols. Most people perhaps do. I don't know. That's one of the reasons we want to talk about it with jurors. And so we want to follow up. If anybody says, yes, I think those symbols, the old Georgia state flag, which we presume will be a part of the case now, if I get told right here, right now, that that's not a part of the case, then I'd like to withdraw the question. I've tried to pick questions here that are indeed related to the subject matter, no matter how small it may be in this case. And there is an old Georgia state flag tag on the front of Travis McMichael's truck that's visible in some of the body cam video that we've received in discovery. And I believe there was some discussion at one of our motions hearings, and I can't remember which motion or how it came up, regarding the admissibility of that image. There's no evidence we expect in the case that Ahmaud Arbery saw it on the front of Travis McMichael's truck.
That matter was not addressed at our last motion hearing. I believe the motion in limine was filed after the last motion hearing, so it's still pending.
All right. Well, without knowing which way the court may rule on that, or which way the state may intend to present their case with respect to it, this question we wrote anticipating that it would be or could be admitted into evidence. And again, if it's not going to be in the case, then we don't want to ask this question. We're only asking it in case that image is part of the case. And so going on
to your
22. We withdraw 22. I don't know if that's your 23. That's the N-word question.
My 23.
Yeah, we're withdrawing that one.
Then your 23 to 26.
All right. Again, 23 is the media question, whether the media has done a good job covering this case fairly. You know, our concern, Your Honor, here is that
we're off then. That is not what I have. That question is much earlier on, I believe. So my 23 is the question about the M-word. My 24 is, do you believe that a citizen should never attempt to detain a person suspected of a crime under any circumstances? 25 is, do you think that a psychologist or psychiatrist can find a mental illness in just about everybody? And then 26 is, do you think that mental health professionals prescribe medication too often?
So you don't have the media question at all, it doesn't sound like.
I believe it's number 17.
Oh, maybe that's how I got off. Okay. 17 is the media question.
That's what I have.
I may have moved it then, but I have it here as my 24, or 23 rather. And the question is, do you agree with this statement? The media has done a good job covering this case fairly. Again, the defense to the question is that is under 15-12-133 again. It's designed to discover inclination, leaning, or bias in favor of the state and against the defendants based upon a belief that media reports on this case have been accurate, complete, and true. And in the beginning especially, it has changed some, but in the beginning the vast majority of media coverage characterized the defendants as white, racist murderers who saw Ahmaud Arbery in their white neighborhood out for a Sunday jog, and so they got in their truck with guns, chased, trapped, and executed him. In fact, those are the exact words that the state used in the preliminary hearing in June 2020. And that got widely reported, was said right here in this courtroom. And so many people who might think the media has done a good job, and by and large the media does do a good job, but if they latched on to those early reports and fixed their opinions about the case based on those are jurors we'd like to talk to and find out if that's the way they view this case, and we're not able to move them from it. So the next one is that was objected to is the citizen should never attempt to detain a person suspected of a crime under any circumstances. Here we're looking for potential legal impairment. We expect the court will give the jury the charge at the end of the case on the citizen's arrest statute as it existed in February 2020. And if there are jurors who are unable to follow the charge of the court, couldn't consider it as a potential defense, not that they have to accept it. We're not looking for a prejudgment. We're not offering a hypothetical. How would you vote if these were the facts? We're asking whether a juror can give meaningful consideration to a law that they will hear and be able to decide whether the facts of the case fit within that law or not. They can decide either way, but if they say up front, we don't believe a citizen should ever attempt to detain a person suspected of a crime, no matter what the circumstances are, then that is somebody who is legally impaired and unable to be a fair and impartial juror with respect to the subject matter of this case. So 1512-133 is our defense. And then is it the mental health, number 26?
5 and 6 on yours.
25 and 26. Yes, I know that there's been a pretrial ruling concerning the mental health issue related to Ahmaud Arbery. Our concern in not asking the question, though, to the jury and exploring this is that there's a possibility that the trial itself might change the court's ruling, and that mental health may actually come into the case at some point. There's a possibility that either the state would inject it or open the door to it from the defense side, and the court would need to then revisit that ruling. And if that happened, and we have jurors on there who have attitudes that might have been learned by asking these two questions, those would be jurors we may have stricken had we known their views. So, go ahead.
I can interrupt with that issue. You realize Mr. Hope's just gotten out of another trial, so there were a few things filed while he was in trial, and one of those is a motion in limine by the state to prohibit the defense from introducing the second toxicology report, which has the absence of Zyprexa and the presence of THC. And that is still pending before Your Honor.
So these questions would go to that issue. Yeah, there you go, Your Honor. What she said.
Yeah, let's, and I understand the issue there with trial, but we're going to keep one counsel at a time on issues, so.
All right.
And then 29 on yours.
Yes, our concern here, and again, this is a 1512-133 question. This goes to any inclination, leaning, bias. If a juror was concerned, for example, that if they were on our case, heard the case, and then honestly thought that the correct verdict would be not guilty, and yet had thoughts in their mind or discussion among their fellow jurors that if we do acquit these defendants, our own safety may be at risk, the safety of our family, our reputation, our livelihood, our business, all of those could be legitimate concerns based on what has happened in the United States in the wake of jury trials going way back, not just in the recent year and a half, but we've seen it many times where communities are thrown into great chaos after a courtroom has engaged in a trial and a verdict's been reached. And it's not unreasonable to think that some jurors who live here in Glynn County would come into this case with those concerns on their mind. And it could influence, I'm not saying it will, but it's possible that it could influence the verdict they choose. So that's the reason for that question. It's a 1512-133. I think that's it.
Mr. Goff.
Yes, Your
brief point to make on it as well.
Your Honor, first, for the record, we don't believe this is a case about race. We're aware that that's come up. We don't believe that, but just because we're not at submitting independent questions to the court, we're counting on the counsel for the state and the McMichael defendants asking these questions. I want to formally adopt, say, for example, a plane crashed into the Hoag's Hotel tomorrow and they disappeared from this trial. I would probably ask most of the questions that they've got. I specifically want to adopt 10, 11, 13, 12, 13, 14, 20, all the way from 12 to 21, 20, I think 23 they withdrew, 24, 26, 29. We would want to adopt those questions for the sake of preserving the record for appeal. It would be an awkward circumstance if the McMichael defendants were granted a new trial because their selection was restricted and Mr. Bryan didn't get the benefit of that because we didn't formally preserve the right to ask those questions on the record. And beyond that, I have nothing further to say.
Thank you, Mr. Scott. Mr. Shepard.
Thank you, Your Honor. Just to add a little bit of context, the question on the Confederate flag was also raised because we understand from discussions with the state that they intend to make it an issue in the case and perhaps to argue its relevance to the decisions made by the McMichaels on that day. And so for that reason, we included it because we thought it would essentially open the issue, not call for a narrative response, just a hand raise that we could follow up then. The other issue that we have, Your Honor, is about the psychologist, psychiatrist, mental illness, and the prescription issue. Again, these are just ways to get jurors to identify themselves through a yes answer that they have some personal experience or personal opinions about these things. The court has ruled that Mr. Arbery's medical records cannot come in. The court has so far ruled that we can't put in his diagnosis or the fact that he was being treated for a mental disorder. However, there is evidence in the case, and we think it'll be in the state's presentation as they begin to offer statements from Travis McMichael. Several times Travis mentioned to the officer when he gave his interview that he noticed something was off or wrong with Mr. Arbery in the way that he was responding, not communicating, and that caused him to make decisions that day not to further engage with Mr. Arbery as he was trying to keep an eye on him. So to the extent that Travis made observations about Mr. Arbery, he reported those, we do believe that there will be a minimal bit of evidence about something was off or wrong with Mr. Arbery on that day. So for that reason, we think these questions should be allowed in addition to the reasons that Mr. Hope put forward.
All right. As to the defendant's general voir dire questions, then the court has reviewed the questions, and the following will be excluded from the general voir dire. What I have is number 10, about shooting an unarmed person under any circumstances the court finds too broad. I don't have the actual cites, but I got the names of the cases. There's Holloway and Stewart, I think, are the two cases the court looked at. Number 11, one should never put him or herself in a situation where he or she might use a firearm to defend themselves. The court finds that that's too close to prejudging evidence in this case. It's Kyles and Stewart. I'm going to permit 13. 14, do you believe that anyone who opposes the Black Lives Matter movement is a racist? I think we covered the Black Lives Matter movement in 13, and the court is going to permit some of these other questions that touches upon race, but again, I don't want to spend 10, 12 questions dealing on that issue. So 14, again, Black Lives Matter is not a party to this crime, party to this case, not part of the criminal prosecution. so that's not going to be permitted. As far as the case being important to revealing racism in the community, again, the court's not going to permit that for similar reasons. As far as
I'm sorry, I could not hear what you just ruled.
I said for the same reasons. Do you agree the statement that this case has been important in revealing racism in our community? Again, as a general voir dire question, the court finds that overly broad. 17, do you agree with this statement? The media has done a fair job covering this case. Again, that's overly broad and potentially prejudging. Now, and again, well, and in line with that, we don't know what they're referring to. There's an entire questionnaire about the media that the parties are going to be able to follow up on. Let's see, working down. The court's going to permit the question about the Confederate flag.
And again, Your Honor, I'm sorry. I think it's the mask. It's very difficult to hear you, but did you say you're admitting it or omitting it?
Permitting.
Permitting.
R19, the flag.
Go.
The question about should a citizen never attempt to detain a person suspected of a crime under any circumstances, that's a legal principle. I understand the defense's request or how it was couched. The question the court would permit would be whether or not the jurors would be following the law. But again, that as far as the way that particular question is asked, the court's not going to permit it. The court is going to permit 25. Do you think that a psychologist or psychiatrist can find a mental illness in just about everybody is permitted? But the second question about prescribing medication, no. Again, those issues really aren't before the court, but I will allow the question simply to see if that fleshes out any additional follow-up with any particular juror. And then 29, are you concerned about the safety, reputation, or your livelihood? The court's not going to permit that. There is a general question, I think, in the states questioning about hardships. I mean, hardships are important as far as the way it's presented in the defendant's questioning. The court's not going to permit it. But the court will permit the remainder of the questions. Any questions about that from the defense?
Judge, with regard to question number 29, I would submit, I don't know if my co-counsel agree with me, but that number 29 is perhaps the most important question that should be asked.
Let me touch on this. This is a case that has garnered significant attention in this community as well as around the country. And I have no doubt that the 1,000 or so individuals that were summoned, when they received that summons, reacted in some way to that, whether that was due to a concern for safety, due to their reputation in the community, how that might be affected if in fact they do participate. This is not an easy thing for anybody. And so I have no doubt that if you ask that question, you will get a response from almost every individual that it affects them in some way. It affects you. It affects Mr. Sheffield. It affects Ms. Dunkowski. It affects everybody in this room. It affects the defendants. It affects the families. So that's why I'm not going to permit it, because as far as a hardship and whether somebody should be struck for cause, that's not going to be relevant to the court.
I'm not suggesting that it would be a challenge for cause necessarily, but if someone does raise their hand and feels that their business is at risk, that their livelihood is at risk, or their children are at risk, we might want to exercise a peremptory challenge on that person.
Again, that question is so broad. If you can figure out a way to tailor that in some way that doesn't effectively have everybody raise their hand under the circumstances of this case, I'll consider it. I understand the question, but the way it's placed here, given the case that we're involved with here, the court's just not going to permit it.
Okay, thank you.
Obviously, the question needs a little work, but the Glynn County Courthouse Annex opened an hour later today, supposedly for some other reason that I think everybody in this town believes it was a security issue. Businesses downtown, as we are sitting here, are deciding whether they should board up their.
One thing, Mr. when I put my hand up like this, you need to stop. Here's the court's position. The more we talk about this, the greater the issue becomes. We're trying a case. Okay? We're going to get a panel in, and there are issues that we need to work through. This particular question, as it is phrased, is not going to be asked. Okay.
So, Your Honor, let me clarify, because I want to make sure I have this correct. Defendants 10 and 11 are out, but number 12 and number 13 will be allowed to be asked. Number 14 is out, but number 15 will be allowed. Is that correct?
No, I didn't notice 15. See, I don't remember discussion about 15. I believe that these movements and demonstrations have had a positive effect on the community. Yeah, I think that's the same as 16. No, that's out. 15 is out.
Thank you. I just wanted to make sure. 20 is in. 23 was withdrawn. 24 is out. 25 is allowed and permitted, but 26 is out and 29 is out. That's what I have.
That is correct.
Thank you, Your Honor.
All right. Strikes. Have the defendants discussed, and I know there was a request for additional strikes, but let's start with the statutory strikes. The 9 strikes, do the defendants intend to divide those up? Are they going to be used jointly? Has there been any discussion about that?
I believe what we'd like to do and hope to do is that all of the defendants will agree on all of the strikes, however many we get. I mean, that would be ideal, rather than, I think the McMichael's teams will certainly agree on all of our peremptory strikes. I have not discussed it with Mr. Bryan's counsel, so I'll let them speak to that, but ideally I'd like for all of us to agree on how to use our peremptory strikes, however many we get.
Mr. Goff.
Your Honor, I'm always open to agreeing with counsel on anything, and it would probably facilitate jury selection if that were possible in an ideal world. But out of an abundance of caution, I want my 3, 5, 10, whatever number of strikes it is, I want the ability to exercise them independently if there is a difference. Now, if we're not going to use them, we could entertain a request to cede some of those, but I want 1/3, the right to exercise 1/3 of the strikes that are available to the defense.
Well, that court put the court in a position where I'm going to have to divide up the 9 then. Whether they're used jointly amongst the McMichaels, that's really up to the McMichaels if that can be agreed, but it sounds like we don't have full agreement across the board. So from a starting point, the strikes will be divided up 3, 3, and 3. There was a motion for additional strikes. Let's get specific on the numbers that folks are requesting. So if the defense is prepared to go ahead and address that, and then the state also will go ahead and address that.
Yes, Your Honor, we did in July of 2021 in a motion we filed number 5.4, which I guess is the motion on the table right now. At the end, we request the court exercise its discretion and grant each defendant an additional 5 peremptory challenges that the defendants would exercise jointly. So that would take us up to 14 total. I think we can figure out how to divide them, is that right? See the last sentence.
Yeah, my understanding from the motion was there was the request, I'm permitted to go up to 5. The court has some discretion here.
Per defendant.
Per defendant.
Yeah, that's what we asked for back in July.
Yeah, that was my understanding.
So 15. Yeah. Yeah. 24.
24 strikes, Your Honor, that's what we're looking for.
Okay.
Sorry about that, guys.
From the state.
Your Honor, we would request the same amount of strikes as the defense. We don't believe 5 each is necessary. That seems like a bit much, but we would just ask in fairness that the court give us the same additional amount of strikes.
I'm curious to know what the basis is for it being unnecessary, from the state's opinion.
Well, Judge, it's just that we need to get a jury in the case, so 15 additional strikes just seems like a bit much, but of course it's within this court's discretion.
If I may be heard.
Yes.
Obviously, we will accept all the peremptory challenges that the court will provide. We're happy to have them. I'm just not used to seeing the state use all the strikes that they have, much less ask for more. I think the rationale for the defense getting extra strikes is completely separate and apart from that of the state. But obviously, it's within the discretion of the court.
Let me ask, is one of the issues the court needs to work through is on alternates. We're carrying a number of extra alternates. And I don't need an answer from the parties right now, but I do want to think through numbers. Normally, it's 1 strike per alternate. And that's going to add a lot of strikes into the alternate pool. And it's been done a couple different ways, and I've done it a couple different ways. And if it was 1 strike per alternate, it's 1 strike per alternate per party, which means 4 strikes per alternate. That's a considerable sum. I'm going to propose, and I'm not asking the parties to agree to it now, but if there can be some discussion, particularly on the defense side with regard to alternates and strikes, that may be helpful to the court, if that can be consolidated in some way or some sort of agreement, because that would help with numbers, because that's really where the numbers start adding up considerably. But I don't think we need to reach that until we get to actual selection.
How many alternates are we looking at?
I can carry, I believe the way we've got this set up is I'm going to be carrying 4 alternates, which again, with 4 alternates, that's a considerable number of strikes on the back end. Okay, so we'll revisit that at some point. I just wanted to plant that seed. Okay. All right, the court's inclined to go ahead and grant, well, first of all, we'll divide up the statutory strikes amongst the defendants, 3, 3, and 3. The court's going to grant the request for 5 additional strikes for each party. The court is also granting the state an additional 3 strikes, giving them a total of 12. So that's how we'll go ahead with strikes. Does everybody understand the court's instruction on that?
Thank you.
So each defendant will have 8 strikes in this case.
Correct.
Thank you.
And the state will have 12. There was a reference during the argument or the presentations to the court on general questions about the court reading the indictment. Every court does this a little bit differently, and I realize we have lawyers from a number of jurisdictions, so I do want to explain how I do it so that there's no confusion about it. In my opening to the panel, I do not read the indictment. I don't read the indictment during jury selection, and I do not read the indictment during my preliminary charge. I simply reference the charges that are there. The indictment is the state's statement on the charges itself. The court's position is it's up to the state to explain the indictment, and just reading it doesn't do that. The court's instruction also instructs the panel to refer to the indictment if there are any questions about the charges that are brought by the state. So again, the court does not intend to read the actual language of the indictment, just the charges themselves. Want to clear that up before we got into it.
So Your Honor, that's what I'm understanding you saying is that in opening statement, if the state then goes through, this is what they're charged with, and this is the elements we're going to go ahead and prove, and this then segues into our presentation of what we expect the evidence to be, that's what you're expecting the state to do, because that's what the state would like to do.
Right, that it is the state's indictment, so the state needs to explain what the charges are and what they need to prove.
Great, thank you, Your Honor.
Okay, anything from the defense on that?
No, thank you.
All right, as far as jury selection then, anything further from the state? We've got, let's see, from a timing standpoint, it's about 11:45, so we've got about an hour and 15 minutes before we bring the first panel in.
Nothing as it pertains specifically to the voir dire, and I just want to be clear. I believe that we came to a modicum of accord on the pre-charge, but that's the pre-charge after we get the jury. That's the pre-charge before opening statement.
I've gone through that. I have a draft of that. I'll go ahead and share the draft with the parties. I just haven't gotten around to doing that yet.
Thank you, Your Honor. So then you're going to go ahead and have the clerk or yourself do the statutory questions, and then the state will do its general. The defense will then do their general.
Correct.
Thank you, Your Honor.
Okay, and I'll coordinate with the clerk.
Thank you.
Is the goal, Your Honor, this morning that we will be handed over those questionnaires?
Yes, we should be, by the time we get started, which I believe is going to be happening, is you'll be getting a binder with each panel that has the questionnaires as well as the general information sheet that's been filled out for each individual member of the panel. Now, instructions on that. Those binders do not leave the courthouse. Okay? But those are, each party will have their own binder, which will contain a questionnaire for each one of the prospective jurors.
Okay.
Your Honor, let me understand the notion that we cannot take the juror questionnaire responses with us in the evening to work on decisions about...
I didn't actually say that. So are you asking to do that?
Yes, we are asking to do that.
So that information is for counsel's purview. It is not to be disseminated by anyone outside the part or to anyone outside the parties. Now, understanding that the court is, well, that'll be a ruling of the court and will subject to any party who violates that to contempt. We'll do it that way.
Absolutely. Thank you, Your Honor. The other is, we had asked the court in a motion 5.3 to withhold the identity of the alternate jurors until the close of the evidence. I don't see that the court's ever ruled on that. Is that something the court is going to grant to us?
Yeah, we haven't ruled on it. I will tell you my practice is generally not to tell alternates that they are alternates, that they are all members of the panel. Now, they'll be numbered. I mean, they can try to work through it as best they can, but as far as I'm concerned, all 16 members of the panel are active jurors in the case until otherwise ordered by the court.
Very good. I think that keeps them more engaged as well. This is another issue with respect to voir dire or the jury selection process. Our motion 5.8 regarding the method of selecting the alternate jurors, the court had indicated in its trial notice, as I set forth on paragraph 2 of this motion that...
Let me get there.
Sure.
5.2.
Yes, Your Honor. 5.8, excuse me.
5.8. Interestingly, I go to 5.7. So, when was it filed?
I see it stamped filed 5.8, motion regarding method of selection of alternate jurors.
Maybe in a different part. Go ahead, I'll catch up with you.
Well, paragraph 2, I'm quoting your original trial notice where you said that once a jury of 12 has been selected, the same process will then be applied to the alternate juror selections, beginning with the next qualified panel member. It may have just been the way you wrote it, but it made me concerned that you were not going to afford us the entire qualified panel, that magic number of the 12 jurors, the number of strikes that the state has and the number of strikes in total that the defendant has, and then proceeding down from that number into the selection of the alternates. I set forward an example of how that could be prejudicial really to both sides. But as the court knows, jury selection is a strategic matter. And so there may be strikes that we do not exercise near the end of the magic number of qualified jurors, which would mean that we have already, where the law says we get a juror to us that goes to the state, they can accept or reject, then each juror, potential juror, must be put on the defense for us to accept or reject. If the court were to go directly to the very next number of the prospective jurors to begin the selection of alternates, it makes it impossible to have a strategic method of making decisions about striking or not exercising strikes. I think when you read the motion, if you could give some consideration to the idea that it's completely within your discretion, but for the vast majority of cases that we try, we know exactly where to draw the line at the magic number and where we're going to begin selection of alternate jurors. Otherwise, we could end up having to have that same juror put upon us twice and having to either choose or forego a selection more than once.
We may be overanalyzing this. We start at one. One is either accepted or rejected. We move to two. And then once we get to 12 qualified jurors, all that was supposed to indicate was we just start, because the alternates, the way the strikes work, you get a strike per alternate. That's the only reason I even put a reference in there to choosing alternates. Alternates get picked exactly the same way. We just keep marching forward. Whoever the next available juror is either qualified or is either struck or not struck as an alternate.
That is the method that we object to. That what we're asking for is that we'll all know where the main panel of qualified jurors ends and where the selection of alternates will begin. It won't change or delay or affect our need to qualify enough jurors for that to happen.
I understand what you're saying. I'll think that through. That's not the way I do it. I'll go ahead and take a look at your motion and I'll take it into consideration.
I appreciate it, Your Honor. And then the next question we had was with respect to logistics, so that we can begin to have our charts prepared. When 20 people come in for the panel, where do you propose putting them, and how is this courtroom going to look so that we can make our charts?
Remember, we're not using this courtroom for the 20.
I did not know that.
Yeah, no, I've said all along we're using the jury assembly room to impanel the 20 because that gives us a lot more room to spread everybody out. And then individual voir dire, we can move individuals into the courtroom for individual voir dire and keep the panel together in the jury assembly room.
Excellent. So we'll have an opportunity before then to go in there and see how do you have numbers on those chairs, or will you?
Are they numbered? Yeah, I think they're numbered. They're all marked. You can see sight lines if you want to go ahead and take a look at it before lunch. You can see where the sight lines are. We've done what we can for sight lines. We've done what we can for audio, and it's set up to work that way.
Very good. Thank you, Your Honor. And my last question, is the court able to tell us how many people showed up of the 600 who were summoned this morning?
I do not know.
Thank you, Your Honor.
Your Honor, I have two matters. Number one is I just want to be clear. When we're proceeding with the actual jury selection after all the questions are done, I presume we're going on the silent strike method. I just want to make sure, since I have my own separate allotment of jurors, that the bailiff is going to take the strike list to the state first, then to the McMichael defendants, and then come over to me. So I don't want to have to confer with them if I don't want to on exercising my strikes. So that
I'm happy to do it that way.
Thank you, Your Honor. The second matter is, it's never come up before, but it seems like a good idea. Is there any reason why, after the jury is selected, why we can't renumber the jurors with different numbers so they can't tell which juror is 1 or 12 or which are the alternates? Just reassign them a new numbering or lettering system so that they can't tell.
You're asking me to shuffle the deck.
It looks like a shuffled deck. We haven't actually shuffled it, but it looks that way.
Remind me of that, Mr. Goff.
Yes, Your Honor.
Yeah, I don't think that's an unreasonable request if I understand what's being asked. It's just if you're juror 1, your sticker could say you're juror 13, but you remain juror number 1.
Yeah, that way juror number 15 or 16 doesn't really know whether they're one of the actual 12 or not. So they'll pay more attention through the trial. And on that note, if it's possible, I really could use a bathroom break.
All right. Well, we are, as I understand it, then we have addressed the matters before Dyer. I believe we are ready to go. And that being the case, we'll go ahead and recess. What we'll do is I'm going to ask that we reconvene then in the jury assembly room at 1 o'clock. Anything further from the state?
Just as to when we would be receiving the binders, will that be before 1 o'clock?
I sure hope so.
Thank you, Judge.
Okay. Anything from Travis McMichael? Nothing further. From Greg McMichael? Take note. Mr. Goff?
Is the attorney workroom now been freed for defense counsel for use?
Nobody has updated me on the discussions, so I'm not aware of any changes. All right.
I believe we are in progress on that, and I do not have an update at this time, but we will attempt to figure out over lunch.
Thank you.
All right. Thank you. We are in recess until 1 o'clock.
heard and stuff, so we just thought we'd take the opportunity to come out and show solidarity and let them know they're not in this alone.
I'm gonna ask you that same question again. Is that your phone? That's not mine.
Yeah, I
right?
was just.
Oh, okay. So I want to make sure.
Everybody sent me up because I did a video.
Oh, really?
Okay. Let me sit it to the side.
Sorry. I thought we were like, oh no. But now they're like, can I get the video? Oh. Got the little dots.
No problem.
Okay, we are good. We're good to go. Okay, so we can probably start over here on me, Marcus. I'll just put this. Hello, everybody on the live stream. Are we good to go? We're out here in the courtyard. We just kind of want to give you a look at what's going on. A lot of people who are over here just went to maybe go get lunch because there is a recess until 1 p.m. But we're going to just talk to the people who are here. Like we were talking to you because you said you came from Chicago, but you were in Waycross, North Carolina.
Yes.
I talked to some other people who are from Chicago. Yeah, just why did you feel like it was so important to be here?
Well, first of all, I have 2 sons and a daughter, and they're all grown and they're out here in this world. And so I can't understand what his mother's going through, but I just want to let her know and the father know and their family know that we're here for them, whether we know them or not. And if only thing I can do is come out here and sit and show that it matters to me, then that's what I'm going to do.
And I'm guessing you were here when people just came out of the courthouse when it broke, right? Did you see the family and like their faces?
I saw his mother, and she's poised as always. I can't imagine what she's been through, but I see she has a support system with her family and with us in the world.
So I was picturing maybe if she came out and looked over at you guys, that's probably what you wanted.
She focused. She was looking straight. Somebody said, "I love you." She responded, and that wasn't even needed, but it just shows her character.
Yeah, definitely. Thanks for talking with us. What was your name? I didn't get it earlier.
Joy.
Joy. What's
Yes.
your last name?
Graves.
Okay, is
Yes.
it just spelled regular in case we need that?
Joy. Graves. Graves.
Gotcha. Thanks, because that's always the first question we ask.
Okay.
All right. Well, thank you. I guess we're gonna kind of go along here. A lot of the people ran away. I'm guessing they probably went to lunch, but we'll give you a little look around anyways, because like she came from North Carolina. We talked to some other people who came from much further away too. We talked to people earlier who came from Milwaukee. Do you want to walk over this way? We can just kind of show around. But we talked to some people who came from Milwaukee, and they named people from Chicago, California, and they were saying that even just that really hopefully will show the family that there's support from all over for this. And let's see who else might want to talk with us. Excuse me.
Yes.
Hi, we work at First Coast News. We're doing a live stream right now.
Okay.
Would you be up for talking with us about like why you wanted to come out and everything?
Sure.
Thank you.
You're welcome.
Everyone's so nice. I'll just hold this over here like
Okay.
this. So what is your name and why did you want to come out here?
My name is Adrian. I'm here to support the Arbery family and hope that justice is served. Okay, this is a long fight that unfortunately we still have to endure, and hopefully we're coming to the end of this.
And are you from Brunswick?
No, I'm from Pennsylvania.
So you had a long journey. How long did it take for you to get here?
I was asleep for a lot of it, so I believe it was about 14 hours, if that's what I'm told. So
this is definitely something, I mean, people all over feel really strongly about
Yes,
this. Do you think you'll kind of take this experience home with you? And are you active there as well?
Absolutely, yes. I'm with the Transformative Justice Coalition, and we are here to love and support the Arbery family and other important causes, voter registration and justice for everyone.
And could you tell me a little bit more about the Transformative Justice Coalition? Do you load up on buses like this a lot and go out to support families like this?
Absolutely, that's exactly what we do. You stated it very well.
Great. Well, thank
Yes.
you for. Oh, did you want to add more?
No, that's it.
Thanks for talking with us. Could I get your name spelling as well, just in case we need it later?
Sure, Adrienne, Adrienne. I prefer not to give my last name.
No problem.
Okay?
Yeah. No,
All right.
Thank you so much.
You're welcome. Thank
So,
you.
And so, let's see.
Who are you with again?
We are with First Coast News.
First Coast News. Thank you.
Yeah, thank you.
You're welcome.
And we're going to be live here again at 12:30, so I'm just double checking that we are all good on this end. And we can kind of recap a little bit about what's been happening. Maybe we can do it in the shade though, so we're not really sweaty by the time we have to go live again. Oh, we're still live streaming the whole thing. This is all online right now. So, alright, so yeah, let's talk a little bit about what's been going on with jury selection. I know that Keitha is way over there. We could give kind of the lay of the land actually before we do that. So we have over here, if anyone ends up coming out, all of the media is put over there, and then all of the supporters and other people who have just been here are outside on the side over this way. We also have been talking to a lot of different people from different church and religious organizations. There's a rabbi, a reverend. They were out here over on the steps this morning, and they were all singing and praying together. And then they talked to all of us, and a lot of the reoccurring things that people have been saying is that they just want there to be peace, and that they're going to show up so that they can show that people really support that. It's been the same thing that people from all over have been telling us. But what's been going on inside is, now that it's been recess, it will start for real basically at 1 o'clock. But they were going over the specific questions to ask jurors. So one question, like we said in our live shot, had to do with a flag. Hey, good afternoon. It was asking if the person thinks that Confederate flag is a racist symbol. Another one asked if they think anyone who opposes Black Lives Matter is racist. There are a lot of specific questions like that. If you haven't ever watched anything quite with court before, it was not the most interesting, but it was definitely very necessary because they're trying to go over different biases. One, I believe it was the defense. They were talking about the guns, trying to tell if someone was for guns or not, and just going through things like that. And there are a lot of questions for these jurors as well. It's expected to take 2 weeks for jury selection. It's really going to be very hard to find people who don't feel some way about this, because I mean, even from these chairs, this is just a small part of the population, and there are a lot of people out here and a lot of people in this. It's a small town. The Arbery family is very big. I talked to 2 of the aunts earlier, and she's told me that she's one of 8 different kids. So there's a lot of people here that know the family or may know the defendants' families as well. Now let's see. What else would be good to show for this? We could talk. Yeah. We could talk to another person. I wish we could talk with the viewers and they could tell us what they would like to see. Remember? Yeah. All right. Let's see. You don't want to do an interview? Let's see. Well, we haven't been over this way. All right, let's do another interview with someone. Yeah. Will you guys do an interview? We are actually we're doing a live stream right now, so it's pretty casual.
Oh no, I'm not. You know, we took an oath, and we can't really say they may, but I'm gonna just keep with my oath that I signed.
Oh, no interviews. No worries. Thank you anyways. Let's see, and she's on the phone. Everyone went to get lunch, I guess. Is there a food truck out there?
No, they brought lunch for us.
Oh, that's great. Okay. Thank you. They probably couldn't hear that, but they said that they brought lunch for them. Oh, really? Well, we can see who else wants to talk to us. I'm not entirely sure what to show around here. But gotta keep it interesting because people are watching this. Excuse me. Would you all be up for talking with us about why you wanted to come out?
Just for justice.
For justice?
For justice.
Simple. That was all she going along. All right, well, we can talk a little bit more about some of the other things going on with jury selection. And then we'll have to go live in a couple minutes here. Also, if anyone isn't following Kaylee Tracy, she's the one who's actually inside. They have the reporters and all the media in a separate room from where the jury selection and the trial is actually happening, and she's inside that room. The rest of us are out here watching it on First Coast News, and so that's how we're getting what's going on. But Kaylee has been, every little detail, she's been tweeting it. Oh, what's up? One bar on the battery? Alright, we might have to switch out this battery before. Well, we can like walk and talk down over there so that one bar left of battery. All right. Juries, I suppose I could just read a little bit and recap what we're doing while we're talking. This is the way to the media area. But again, what's going on here this morning, or this afternoon now, if you watch it on the First Coast News app, that's how you can see everything that's going on inside the courtroom. That's how we've been watching it. But the who are accused in the death of Ahmaud Arbery, starting today and recess right now, it'll be 1 o'clock. There are been in If you're just joining us, Arbery, of course, was shot and killed on February 23rd in 2020. One video to the public shows the two armed men in a truck approaching the 25-year-old as he ran. He was in Satilla Shores, and I think we're gonna switch out the battery right here, so stand by. Okay, I think we're still live streaming, so I can just tell more. Alright, I'm gonna recap a little bit about what we're talking about. Oh, they say they're a minute out to the second half hour of the show. Newscast.
Hey, before you guys put up another live shot, you realize like there's nothing to go back to, right? You'd be putting up a live shot for us to talk and then closing it again. Because you still want to do that? Okay. Okay.
Oh, I needed to know what I was doing.
Yeah, not unless.
And welcome in. You are watching First Coast News' live online coverage of the trial and the death of Ahmaud Arbery. Ahmaud Arbery, at just 25 years old, back in February of 2020, was shot and killed in the Satilla Shores neighborhood here in Brunswick. Now, this is a trial that has gained national attention. We already have demonstrators out here in front of the courthouse, in the Glynn County Courthouse, ahead of things really getting ramped up. Now, today is day one in jury selection. We know a very wide net has been cast to try to get an impartial jury seated. In the end, it will ultimately, they're aiming to get 12 jurors and 4 alternates. Now, right now, things are in recess, and they are expected to get back into that courtroom at 1 o'clock this afternoon. Until then, I'm joined now by Ann Schindler. Ann has so many titles, by the way. She wears a lot of hats. She, right now, is on your side with the latest on this case, where things currently stand. And you didn't have a chance to go inside the courtroom. We know Kaylee Tracy was in there, but you were listening intently, just like many of us were. What did you gather from what you were hearing earlier today?
Well, it sounds like we are not going to be able to have a live feed into jury selection. As it stands right now, unless the judge issues a new order or changes his mind, he's not going to allow a stream that allows, juror voices. Obviously, we're not allowed to photograph jurors anyway, but this would basically exclude the media from jury selection. Now there's, the motion pending that media has brought to ask to be able to have someone in the room as a pooled journalist, and then also to be allowed to at least broadcast voices during jury selection. But this judge is not in his own courtroom, and so some of the technical parts he admitted he didn't know kind of what the setup was. He, of course, is from Chatham County, and he's down here because 5 judges previously recused themselves from this case because they were too close to the people involved.
Somehow connected. I'm glad you brought up that point, because that kind of shines a light in the situation when it comes to actual jury selection at this point. How can you possibly find an impartial jury in a town as small as Brunswick, even Glynn County? Because speaking with the Arbery family, just talking with Marcus Arbery, he has 9 brothers and sisters. Think about the connections in a small town such as Brunswick. You talk with anyone. I spoke with the commissioner. They all know each other. Hey, do you know the sheriff? Yeah, here's his phone number. How would it be possible to find an impartial jury in a situation like that?
I mean, again, when they look for impartial juries, they look for people who say they can set aside what they know about the case. People who haven't formed a firm and fixed opinion about what the guilt or innocence, or the facts of the case, and that they'll leave themselves open to what they hear in court. Right. But yeah, it's going to be tough. And, there's already some rumblings and discussions that we're hearing from people in the legal community that, they may go through this process and reach a point at which they say we can't get an impartial jury here, and they would move it. But they're going to go through the process. They're going to go and see if they can, out of this pool of 1,000 people, find 12 qualified jurors and 4 alternates. But it's a tall order. It's a small town, and like you said, everybody's paying attention, not just the nation, but everybody in this town is riveted. I mean, we just had a gentleman come by who works at the port across the street. He says everybody's paying attention, everybody's following every little bit of this case. So it's going to be tough to find a jury.
Yeah. You mentioned the process. You were actually at Selden Park earlier today where we know potential jurors are actually coming in, being questioned. They're trying to weed things out as much as possible. They're being asked simple questions to see. Some people simply can't serve on a jury.
Right.
So let's talk about that while you're out there.
So they do this hardship screening at the very beginning. That's over at is it Sheldon
Sheldon.
Park? Sheldon Park. The sheriff was out there this morning. A lot of law enforcement was out there this morning. They're basically doing the hardship screening, which is basically like if you can't sit, for instance, for long periods of time, if you're a caregiver and you can't leave the person that you're caring even long enough to go through the jury selection process. Sometimes it can be financial. Typically, they handle that a little bit more to voir dire. So this is really, truly like if you just cannot be in the courtroom, if you have some sort of medical emergency, situations like that. So they're doing that initial screening, and now they're going to start bringing over the people who are at least at that level of qualification to the courthouse at 1 o'clock. The first group of 20 is going to come in. And then they're going to be answering the jury questionnaire. And that is what they're asking specific questions. What do you know about the case? And some of their alliances, they wanted to ask questions about, do people have positions about Black Lives Matter? Have people participated in any, rallies in this case? So that's when they're going to kind of get into the more of the meat of how people are aware of this case and what they've done to follow it.
And just to clarify, it's Selden Park where you were earlier, that gymnasium there. And I want to ask you this because, as again, you're watching things closely. Let's talk about the process itself, what we can see happening at this point. As you mentioned, 20 potential jurors will be there at 1 o'clock. Then what's set to happen after they're being questioned? What can we see slowly happen?
Well, again, we may not see any of it, right? Because we're as far as we know,
right now.
Media may not be allowed in for that process. It does sound like they're going to try to have at least one pool person in there, but it wouldn't be with, cameras or microphones. It would really be somebody that would kind of be sitting in there for the process and then report back. So there's going to be some people, when they say that they have had exposure to the case, or when they say that they have a position on the case, or they know something about the case, then they're going to try to do an individual questioning of those jurors. Right. It's really important to the attorneys on both sides that what somebody knows or perhaps their position on the case doesn't taint the rest of the jury pool. Mm-hmm. And so they're keeping it very small. They're going to do these by groups of 20, and then they're going to do these kind of closed door sessions essentially with potential jurors to find out what their individual bias may be or what their individual position may be. They're also really concerned about jurors feeling comfortable talking about it. I mean, that's kind of one of the main things. They want to make sure that people feel that they can speak their mind freely and that they're not, constrained by having a larger audience watching what they're saying. And so I think they really want people to speak from their heart. They want people to be honest. And I think they're a little concerned that the attention that's on this case might, constrain their ability to be frank and honest.
Again, the small town aspect complicates things because you're talking about people being honest, and you're my mailman. I know that what I say out loud here is going to possibly spread. So there's a lot of different nuances to this case that really complicates things, but we really just have to wait and see how things play out. I'm sure the judge will do his very best to try to ultimately seat an impartial jury, again, of 12 with 4 alternates. And as you mentioned, we won't be in there as we planned, but we will have updates. And as soon as they come in here, we'll be sure to bring it to you both on air and online. That's why we keep on telling you to download that First Coast News app for instant updates. As for the online stream, at this point, it doesn't look like it's going to happen right now, but things could change.
Fingers crossed.
Yeah, things could change. All right, folks, your First Coast News coverage on the trial of the death of Ahmaud Arbery will continue, again, both on air and online. Always download that First Coast News app for instant updates. And of course, we have everything for you on firstcoastnews.com, a complete section with the very latest details and taking you all the way back to February of 2020 when Ahmaud Arbery was shot and killed. Again, we are here right now waiting to see what will happen next. At 1 o'clock, we do know that about 20 potential jurors will be brought in here to the Glynn County Courthouse. And as soon as we get updates on that, we'll bring it to you on that First Coast News app. Live in Glynn County, I'm Keitha Nelson.
I realized I should have told you.
Sean.
I'm not sure.
Yes.
I can handle it either way.
Oh, yeah, I know you did.
Test, test, test. 1, 2, test.
Yeah, bring them in. You can put them in a certain order.
Yes, I got it.
Okay. You just set them up here to you?
Yeah, Bob's gonna send them to me, she said she'll send them to me.
Okay.
And then I'll put them where they need to go. Smart, did the judge? No, there's not. I'm going by with that thing.
Sorry, you're this one. You're right here, please.
You're gonna come right over here.
You're gonna figure out this chart.
If you wanna go around there and then sit right where that spot is right there. Give me just a second.
Is there any more?
block, all 20 of us.
Yeah.
Parking is an issue. Parking is an issue.
Oh, yeah, yeah. Oh, so, how many people share?
Well, I mean, more so today.
I guess not.
Just remember where you're sitting at, and just go out here. Yeah, just remember that.
It's going to be
Is that main lobby?
right over here. Right here? It's gonna be right over here. With this blue dot right here. Let me take number 1 and number 4. Number 1, you're right there. All right at the end. Right here. This first one right there. You're going to be. You're gonna be right on here. You got there? This spot here.